All right. The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you and good morning. We are hearing one case today in this Zoom format, and that's Commonwealth versus Kevin Cummings, case number 2021-0714. I understand that both parties arguing today understand the Zoom format, so I'm going to dispense with any preliminaries, but I will introduce the panel to you now. My name is Ariane Buno, and I'm joined today by Justice Mary Sullivan and Justice Sabita Singh. Attorney Peterson, the microphone, I should say, is yours.
Thank you, Your Honor. Good morning, Your Honors. Attorney Kim Peterson for the appellant. May it please the court. First and foremost, not all noxious and disturbing remarks are threats, as we all know. And this case is extremely lacking to prove threats were carried out by this defendant. The police go to the home, 3 police officers, they supposedly hear loud screaming outside the door. They hear the words from a male, "I'll kill you, you C-word." They then knock on the door, a male answers the door, they take him outside, they handcuff him, they sweep the apartment, they see a female inside. They arrest the male. That are the facts of this case. It was a 5-page transcript case. My argument, Your Honors, is there is no way that this defendant can be identified as that voice, first of all, that gave that threat. He was never identified from the police officer that arrested him, that was the voice before and after the threat. He showed no signs of emotion, whether he was upset, angry, sweating profusely. All of that is absent. Additionally, the female, whose name was never given to us, is never ID'd as that was the voice inside. It was pure speculation by this police officer that it was a male voice and a female voice, and therefore the male was the one who made it and the female was the victim. That's all. Additionally, Your Honors, there's no evidence that the victim, that the threat was conveyed to this victim. There's no facts that, again, that the victim, a female, was targeted, that she showed any signs of being upset, again, crying. There's no evidence that the apartment was in disarray, like the curtains would be down or the furniture was turned over. There's none of that as well. And lastly, there's nothing in the context of this to show that there was an actual threat. There's no history between the two that was put into evidence. There's no demeanor. There's nothing to show that this threat was actually a threat at all. The victim's name was never given. The background, whether she felt frightened, not that that's dispositive, but there's absolutely nothing to show that a person with an objective standard would have felt threatened in this incident. I would highlight as well, Your Honor, that the victim did not testify. Her name was never put in the complaint. The only threat was to kill. Quite frankly, I read the 5 pages of transcript being a prior prosecutor, and I honestly do not know how there was a conviction in this case. My client served 6 months for this crime, Your Honors. And for that reason, we would ask that this court find that there was insufficient evidence at that time. Not all noxious and disturbing words are going to be crimes. They're not always going to be threats. And while at the time it seemed very upsetting to the police officers, it may not have been upsetting to the victim. As the defense attorney stated during his argument for a directed verdict, this may be how they talk to each other. There was no evidence he was even speaking to her. He could have been yelling at a television set.
Yes, Peterson, you're correct that might have been the case, but as you said earlier, don't we look at this from an objective point of view?
You would, Your Honor, but given that it would be in context, I think Commonwealth versus Troy T tells it best. You have to take everything together, and just the words themselves don't hold any weight unless we can go and look at, well, this woman would have been upset if she was, could have been a threat if she was crying, if she was emotional, or that they were in a closed area together and maybe he pointed at her, but we have nothing. It's in a complete vacuum how these words were expressed. And even when they took them outside, they don't have any evidence how this woman reacted or how the defendant reacted, whether he was upset and agitated, as the case law like Leonardo L. that I cite. And even the Commonwealth's cases that they put subsequently, the 128 opinions, they all give it some context. And that's what makes a threat. It's not in a vacuum, Your Honor.
But even taking it in the light most favorable to the Commonwealth and viewing all fair inferences and knowing that we need to look at it in an objective manner, with all of those, you're saying the inference could not be made that, it's not simply the threat to kill, but it was also how the person was referred to, right? Putting all that together.
The person referred to, you mean the words that the defendant called the female?
Yes.
I mean, they're just words though. And words, this court and the SJC have both held that words alone are not enough. There's got to be
context.
Right, but there's
some context. It provides some context, doesn't it?
But there is no context because we don't see how these people reacted. We don't see that the defendant was charged. We don't even know if these are the two people. But in the context question itself, the defendant shows there's no testimony to any emotion to either one of them. And the case law has all stated that at least someone would be agitated or they'd be angry or there'd be some background that there was a relationship. There's no relationship. There's nothing in the record that depicts any of this. Why even an objective person would feel threatened or take it as a threat. We don't know if they're complete strangers. We don't know if they're neighbors. We have no idea. But
Well,
even
following up on Justice Singh's point, by using I'll refer to the C word, isn't there a reasonable inference that shows some sort of animus, and also maybe a reasonable inference that there is that the two of the individuals in the apartment know each other? It's not a word that's generally used without some sort of context.
I would argue against that, Your Honor. Just like in Troy T. says, I mean, he calls people dumb blondes, but there's no context as to who he meant by that. Supposedly, there were two people walking by who were blonde, and he said, all those dumb blondes should go too. Now, that inference could have been made that he meant those two people, but the court said that wasn't enough. And that could be true in this case too. He is just, or if it is actually him, we'll have to get to that first part first. If we say it even is the defendant and he yells at that word, it doesn't mean that it is directed to that female voice. We have no visual, no context, no idea where they were standing, anything. As I stated in my second point, he could have been yelling at the television set. And granted, that is an inference, but we have nothing else to say it is actually that person he is yelling to. We have no context.
Well, don't we have the background of an argument that can be heard?
There's supposedly loud screaming.
So that's context.
But it doesn't say what the screaming encompasses. You don't know if they're yelling at a sports game. There's no words that are said. The police officer didn't testify what was contained in it. If there was, he just said loud yelling. That's all, loud screaming, he says. But you scream at the sports events. You scream at a television set. You scream at your pets. There's nothing to say that screaming was directed at this female. And that is the problem with this case. It has so many.
But you're went on mute. Excuse me, your mute button was hit accidentally.
Oh, I haven't touched it. My hands must be waving. I'm sorry. I hope that wasn't for too long.
That was just the last sentence.
My kids go nuts that I talk with my hand all the time. But what I was saying is that it's just the context is completely lacking in this case, and that's the big nut that the Commonwealth has to crack here. Is that it is in a vacuum. Even the victim's name is left out, their past relationship, how these people look. I mean, everything is missing at this case that it is really tough, as I said, as a former prosecutor, and this to say, where is it? Where is the atmosphere that we should be looking at? And it's just not here.
Okay.
And if there's no further questions, I just rest on my brief, Your Honor.
All right. I think we understand your position. As you said, it's not a very lengthy case, but let me just check with the panel, just as Sullivan says, to make sure there's no additional questions that they would like to ask. Seeing none, thank you very much for your argument, and we'll turn now to Attorney Johnson.
Thank you, Your Honor.
Thank you. Good morning, Your Honors. May it please the court, Kayla Johnson for the Commonwealth. The elements of threatening to commit a crime include an expression of intention to inflict a crime on another person and an ability to do so in circumstances that would justify apprehension on the part of the recipient of the threat. And here, the Commonwealth's evidence was thoroughly sufficient to satisfy those requirements. First, I think an important aspect of this case that hasn't been touched upon yet is the fact that officers were dispatched to this particular apartment. And I think that supports a reasonable inference that there was some sort of altercation going on there. And I think that, again, is further confirmed when the officers arrived at the specific apartment that they were dispatched to, and they could hear loud yelling from outside of that apartment. And specifically, the officers heard a male voice yell, "I'll effing kill you, you C word." And then in response to that threat, the officers heard a female respond. And then seconds later, the defendant opened the door to that specific apartment that the officers were dispatched to. And the defendant was the only male inside of that apartment. And after officers entered, they discovered that the victim, a female, was the only other individual in that apartment as well at the time that the officers heard that threat. So based on that evidence, it was certainly a reasonable inference for the judge to infer that the defendant was the person that the officers heard making the threat to the victim, who was the only other individual in the apartment at the time, and directly responded to that threat. And moreover, the Commonwealth's evidence also thoroughly supported a finding that the threat was made in circumstances that would justify apprehension by the victim. As I mentioned, the officers were dispatched to that particular apartment, supporting a reasonable inference that there was some sort of loud altercation going on, enough to warrant someone calling the authorities at that point. And when the officers heard the back and forth between the defendant and the victim, again, they did confirm that they were the only two individuals in that apartment. And such an altercation within the confines of an apartment, and I think especially where officers were dispatched to that particular apartment, would support an inference that a reasonable person would fear that the defendant had both the intention and the ability to carry out such a threat in a confined space such as an apartment.
Simply because they were in a confined space, but there's nothing else in terms of any weapons being out, anything like that. There's no details regarding those circumstances.
No, that's correct, Your Honor. And certainly, I think defense counsel makes a fair point that this case was certainly not overwhelming. But I think when we look at all the evidence, and especially in the light most favorable to the Commonwealth, I think the circumstances do support a reasonable inference that the defendant was the one who made this threat to the victim. And the fact that the authorities were called to this apartment in particular, I think also supports an inference that there was some sort of loud altercation going on. So I think that does move the needle in favor of sufficiency in this case, especially viewing this evidence in the light most favorable to the Commonwealth. And if there are no further questions from Your Honors, the Commonwealth would rest on its brief.
All right, I'll double check, but I don't see any questions from the panel. I want to thank you both very much for the argument today. We'll take the case under advisement and get back to you as soon as we can.